prior dates are expected to move very fastly. This is the indication given by the State Department in last week's video presentation that they did. And there are a lot of things that people need to be aware when the priority dates are going to move. We're going to discuss in two separate segments. One is, if you've already filed the adjustment of status, what are the steps that you need to do? If you have not already filed an adjustment of status, also called as 485, what can be done? If you've already filed the 485 application, there are a couple of things I want you to do. The first thing is that if you have an I-140 pending, for example, the downgrade application of that I-140, have it premium processed, get your I-140 approved, unless you have a child who is a teenager coming from India. That's the main thing. So get your I-140 approved. The second thing is that if you have not submitted the medicals at the time when you submitted the 485 application, you may want to do the interfiling and submit the medicals though. Because right now we are seeing that the USCIS is approving the adjustment of status applications without interviewing. That's a trend that's been going on from the past 2-3 months, especially for the Eb1, actually from past 4 or 5 months. So you may want to have everything ready for the officer. The I-140 has to be approved, the medicals have to be done. These are in your hands. There are two other things that has to happen for your 485 to be approved. The other thing is that the biometrics have to happen and the final action date has to be current. So 4 things. First, medicals. Second, I-140. Third, biometrics. The final action date. 2 things are in your hand, 2 things are not in your hand. If the first 2 things are done, what you have in the hand, most probably the other things, final action date is expected to move. Biometrics are going at a very fast pace right now. They're doing somewhere in October, 3rd week is to 4th week, what you filed in Texas Service Center, they're getting the biometrics appointment. We're seeing surprisingly, the H4 EAD's biometrics are not getting done, but at the same time, 485 biometrics are getting done. So they may be on a path to get these green cards approved faster for you guys. So be on the watchful about these things, and if the final action date becomes current, there is a good chance that most of the people who filed the adjustment of status in October, November, and December of 2020 may get their green cards by September. The good part is that the USCIS is waiving the interview requirement for most of the people. Now, if you have not filed the 485 application, what are the steps that you need to do? The number 1 step that you need to do is that if you are contemplating leaving the job, if I were you, I'm not going to leave the job because my I-140 is stuck with this employer. You may not want to leave this job and stay with this company. If by any chance you're working with a company where you don't have a labor and I-140 approved, you have it with the previous company, you should try to expedite the perm processing with the current company as much as possible. Or if I were you, maybe contemplate going and joining the old company. That's what if I were you, I would do it. Also think about correcting the birth certificate if you don't have it. Check, verify the documents with your lawyer to see if there is anything else that is required. We have seen the priority date movement in September of 2020. Very surprising. I mean, it surprised everybody. Emily predicted a date, I predicted a date, we both went wrong. It went way ahead of it. And now in 2021, we are predicting the date, hopefully so. We both are wrong and it's going to go more faster. But I want you guys to be prepared to file your adjustment of status in October of 2020. Now, is it required for you to file a downgrade application of I-140 if you have an Eb2? That part is a little bit judgmental. It's up to you. You may want to discuss with your individual lawyer or have a consultation with a lawyer to see if that is at this point of time required or not. Anything else you want to add on the priority date?
Yeah, I think the big thing is just to be prepared for the dates to move faster than what we all expected. When we started seeing the final action dates just barely moving, we were wondering how are they going to approve all these applications that they received in October. They do seem to be catching up on that, which tells us that the final action dates should touch the filing dates by September. That's what we're expecting now. So that means everybody who did file in October should be finishing up, making sure their I-140 is approved, getting the medical done so those can be approved. And then we also have the extra spillover green cards from family-based that'll come in October. So the dates, again, the filing date should jump way forward to allow more people to file. So make sure that you have your perm in place with your current employer so that you can be ready for that, and then deciding on whether to do the downgrade or not just kind of depends on your employer and what the dates are doing over the coming months.
Emily, on the H1b Lottery, now we know that H1b Lottery is selected. Is the lottery over, or is it going to be still done?
Yeah, so we were expecting, we unexpectedly started getting notifications on Saturday morning at 8 a.m. letting us know to check into our accounts. And so we started seeing the selection notices pop up. Didn't see any on Monday, and now here we are Tuesday before March 31st, and USCIS announces that they've actually completed the selection process and they've already notified all of those that were selected. So if you are an employer and you're looking into your selection, your My USCIS account, those that show selected, great, those are selected. The rest that still say submitted, that means they have not been selected in this round and cannot file between April 1st and June 30th. That lottery is over. Now, we could have a second round of lottery like we did last year, just depending on how many people actually file between April 1st and June 30th. You don't have to do anything for that second lottery to happen. It will happen automatically based on all of the registrations that are currently showing as submitted, and we'll get notifications and can file most likely in the fall if that happens. But for those that were hoping to file in this April 1st to June 30th window, if it still shows as submitted, that means you are not selected and will not be able to file.
Emily, if I got selected with company A, but I want to file H1B with company B, can I do it in the lottery system?
No, you cannot. You can only file with the company that you are selected with in the lottery.
My STEM extension is expiring in July of 2020. So if I file in the H1B lottery system right now, can I continue working after July of 2021? Sorry, 21.
Yes, as long as your H1B petition is filed before your OPT expires, requests the start date of October 1st, and is requesting a change of status, yes, you can keep working based on the pending H1B through September 30th. For those that have OPT expiring before the filing deadline of June 30th, your H1B has to be filed earlier. It has to be filed before your OPT expires, not by June 30th. So make sure you get that done in time, otherwise you'll miss the cap gap extension.
Well, I have my mother's cousin's brother's son's marriage that I want to attend. And I am on F1 visa, I got a H1B selected. After filing the change of status application, can I travel to India and come back?
No, we do not recommend that. Your change of status request will be automatically abandoned when you leave. And what we saw last year and the year before is that when your H1B is approved without the change of status, the SEVIS system for F1s automatically kicks you out, even though technically they shouldn't be doing that, but people were not able to come back in on the F1. And then we had so many people that ended up stuck outside the country during a pandemic, which no one could have predicted. But it's just not a great time to travel if you're going through this H1B process between now and October.
Emily, if I'm not selected in the lottery, what are my options?
You have to wait and see if maybe you'll be selected in the second lottery, if there is one. You can, if you're on F1 and you're eligible for the STEM extension, certainly apply for that STEM extension. If you're out of OPT time, you can re-enroll in a school program to continue your F1 status, but please do not enroll in a day one CPT school.
Why not, Emily? I just go there, I don't have to study, and I don't have to go to college, I just get the work permit. Why can't I go to day one CPT?
Yeah, it is very questionable whether these schools are properly following the F1 regulations, and it is likely to come back to bite you later. We've seen so many people that relied on these schools in prior years and they had difficulty getting their H1B approved with a change of status later. They were not able to get the visa stamp at the consulate. Some of them were found to have misrepresented or been subject to fraud determinations, and there's no coming back from something like that. So it's very huge risk for very little reward.
I would suggest that those people who are an OPT or eligible for the STEM extension, even though your H1b might be coming, you got selected in the lottery, I would suggest that you file the STEM extension. You will not be in any loss, because I would like you to play a defensive to file a STEM extension, just in case if there is a H1b that gets denied or so. And if you have any travel plans right now after you get selected in the lottery to go to your home country, living outside this country, you better speak with your lawyer before you embark on the process of journey going outside the country. I would strongly recommend that you avoid all things. If there is any emergency travel, to check with your lawyer before you take any travel plans. Anything else you want to discuss about the lottery?
I think one of the things we're hearing from other attorneys is that the selection rate seems much lower this year compared to previous years. A lot of people are reporting around the 30% rate. So we don't know how many registrations were actually submitted, but our guess based on how many we're seeing selected is that there are many, many more registrations submitted this year compared to last year, because the process is so simple. It's only $10. We may actually have a lot of situations where one individual was submitted multiple times with different companies to try to game the system, and unfortunately that makes it harder for everyone else to be selected. We'll have to wait and see when USCIS actually announces the number that we received. I think last year they didn't do that for quite some time. We found out about it several months later, so we might not know. But that seems to be what's happening based on the lower numbers of selection this year compared to prior years. Consulate appointments, everything seems to be stuck. What are you seeing as trends? How about this Dropbox? Is that helping?
The Dropbox definitely is helping. The relaxation of the Dropbox rule, where if your passport visa is expired within 4 years, mostly if you're an H1, F1, H1b, H4, L1, L2 visa, the Dropbox expansion process has definitely helped. Previously, if your visa has expired, you can only apply for the Dropbox if it's expired within 1 year. Right now, they have increased it to 4 years. A lot of people are asking the question, I changed the company, can I still be eligible for the Dropbox? Yes, if your previous visa was obtained in India, you can still, you're eligible for the Dropbox. With regards to the appointments, Emily, I know that if you try to go online and check yourself, you want to book an appointment, there are none available, and if there are any available, it may even extend all the way to November, as you have spoken with me before. But there are ways to get around it. You have to, every night and day, you go check around, and then see if there is anything that pops up. Sometimes they just pop up, Emily. So we're noticing that, yes, there are sometimes the appointments are popping up in June, but you have to be very vigilant, have to watch very carefully to get those appointments. One thing is for sure though, in September or October of 2020 though, we have seen a lot of cancellations of the appointment. Whoever been appointed, they got their cancellations and kept on postponing. I'm not noticing any of those things. But overall, as you pointed out, that yes, the appointments are backlogged very significantly. All the way until October or November is where the appointment dates are. Only the people who are sneaking in every night and day watching and then getting their appointments are getting appointments in June or July. So anybody who's planning to travel outside the country though, be careful about these things. Now, of course, we're not going to discuss about the ever-changing travel restrictions of the airlines of the different countries. The different countries, what I mean is that, let's say for example, your home country is India, you need to be watchful of the what restrictions India is posing. You need to also look into what restrictions USA is posing. You also need to look into what restrictions the middle country, let's say there are not many flights that go from USA to India. So you will either have to go to the European countries or the Middle Eastern countries. So there are restrictions for the Middle Eastern countries or the European countries. You can't land there and go to your country. You need to be very watchful about all these things. They are ever changing, every week they change. And once a week, they're sometimes changing 3 times a week. It's becoming a nightmare to catch up. So any plans that you have to go outside the country, make sure that you are flexible. If you're not flexible, you may get stuck there in India for a long period of time.
And we also have the travel ban, the H&L travel ban that's set to expire tomorrow. No one has made any announcements so far about whether it will be let to expire or whether it's going to be extended, but we're hopeful that tomorrow might be the last day of the H&L travel ban. So at least we don't have that to worry about, and then we can focus on people who are subject to the different COVID bans.
I heard a rumor that it may be extended until further, Emily. What do you say?
I heard the complete opposite rumor right before I walked in today.
Okay.
So,
we have a different things. Let's see. Next week we will determine you're right.
Yeah.
Hopefully you're right, I'm wrong. Why is that now? Per country limit. When this administration came in, they came in, okay, we're going to bring the comprehensive immigration legislation, we're going to treat everybody equal, and then what? Everything fizzled away now. Nobody talks right now about the per country limit. What's going on there, MB?
Yeah, it was included in Biden's comprehensive immigration bill, which has gone nowhere. And now we have all of these individual bills, the piecemeal approach, they're popping up. Many of them are getting passed in the House. Now we have a healthcare worker one that's got bipartisan support in the Senate. But we're back to these piecemeal, one issue at a time, yet the issue that seemed to be the most popular last year in the House and squeaked by at the Senate at the last minute and couldn't be finalized, no one has brought that up again.
So you're telling there are a lot of piecemeals, including the piecemeal for the agriculture worker. You have a piecemeal for the DACA kids who came when they are under 15. Why isn't there a piecemeal for the per country limit, taking the per country limit off?
Yeah, I don't have a good reason for it. I think we need to be advocating again to get Representative Lofgren to bring that bill back. Obviously, everything starts over again, but it might be because they're wanting to see what happens with this comprehensive bill, because the comprehensive bill does have that provision in it. But I would not rely on that. We've been down this road so many times with comprehensive bills and they go nowhere, and the individual bills go nowhere, but we've got to attack it from both ends and start advocating for that.
One thing I would suggest is that for the per country limit, the champion of per country limit has always been Representative Joe Lofgren from California. She is the person that knows everything, did everything. Unfortunately, a lot of other colleagues of her failed her. So I think it should come back from her again. We may have to contact her to initiate the whole process, because she is also part of the immigration bill, which has the per country limit, but it doesn't seem that it's going anywhere. They cut into pieces, so we may have to have our piece standing out and start working on it. That's the best way of doing it. Let's go to questions, Emily. Now we got the question from Ravi from Facebook. Ravi has initials in his birth certificate. Does the initials have to be expanded names? Well, I would like Ravi to have the initials expanded, but I'm a lawyer in India too. I know how bureaucratic it is to get the things down there, to get it extended. I do understand though. There are ways around it, Ravi. I want you to go to rnlawgroup.com, look into birth affidavit. It says that if you don't have a birth certificate, what are the things that you need to do? Now, in your case, you do have a birth certificate, but I still want you to go to that article. There are alternatives. If there are any deficiencies, you can always get 2 affidavits from 2 different individuals. The draft of that affidavit is there too. You can provide, if you're from India, you can provide Aadhaar card, you can provide a PAN card, you can provide the school certificate, you can provide the medical records, you can provide the hospital birth record. So all these things, you can have the election record, you can have a ration card, all these things you can provide as in addition to the birth certificate to prove that you are Ravi and you are nobody else. So normally they're quite sufficient enough, but if you want to get this thing verified before itself, you can always provide all the documents to a lawyer and have it verified. Hey, does it look okay, or do you need something else? So please, have it done. I want everybody whose priority dates are before 2018, who knows, maybe 2019, to have these things verified and get ready so that you can file in October. October is not that far, it's only 6 months there. So please make everybody, all your documents ready to be filing for the adjustment of status.
Arvind from Facebook recently got his I-140 approved and filed the H4 EAD for his spouse, but now she needs to travel, and he wants to know what will happen to that application and whether premium processing is possible. So I'm assuming that this is just an EAD application filed by itself because she's already in H4 status. So the EAD will not be abandoned if she travels. It's okay if she travels with this application pending. She just had to be in the U.S. when it was filed. As far as premium processing, although Congress directed USCIS to create premium processing for EADs, USCIS has done nothing to implement it, so it's not available, unfortunately. So you'll have to look at the processing times for the service center where her application is pending, and yeah, they're taking a good 6 to 9 months when it's filed by itself, possibly longer.
Krishna from YouTube has this question. I'm working here in USA on H1b. Can I work for a company in Canada or India remotely while working simultaneously in USA on H1b? The answer is no. You do not have work permit to work for the job that you have in Canada or India. The countries at this point of time do not recognize cyberspace as a space. They only recognize the butt space. I spell it out, B-U-T-T. Where your butt sits is where the law is. So if you're logging into Mars, I'm speaking of the SpaceX Mars, or you're logging into Moon, that doesn't mean that you're working in Moon or in the Mars. Your butt is still sitting in United States. You are under this law. You do not have authorization to work for those things. Unless your existing company, they are the clients of your existing company, then that's a different rule. There are ways, if you want to work for the Canadian company or Indian company, where you can have one more United States company concurrently filing H1b, where the client is in Canada or India and you work in United States. That's allowed. But without that, you're not allowed to work for a company in Canada or India without a proper work permit.
Vilaxby from YouTube filed an Eb3 downgrade with adjustment of status 2 weeks ago using the final action dates and wants to know when receipts can be expected. I would say within 30 days. I think they're very much caught up on sending those receipt notices, so there's still a little bit of delay, but nothing like what we were experiencing in October.
Surendra from YouTube has this question. Can a H1b holder travel for a period of 3-week period while their dependents are here on H4 visa? Absolutely. That is, you're just traveling, you're just visiting. You're not going there to stay there. So absolutely, that's definitely not a problem. You're in good shape.
Ramina from Facebook wants to know, when do we expect priority dates to move by? I was under the impression that there will be no movement till October 2021. The filing dates probably won't move until October 2021. The final action dates should be steadily moving towards the current filing dates over the next 6 months through September. So we should see, especially in Eb3, rapid movement to get from the current final action date to the filing date by September. Then in October, we should see the filing date chart jump ahead again because of all the extra green cards, just like we saw last October. And we would expect USCIS to again allow us to use the filing date chart in October of 2021.
Mohit asks this question. Can I upgrade to I-140 premium processing once the adjustment of status become current? He has a teenage kid born in India. Absolutely. Yes, you can upgrade it to premium processing. Now here is it, Mohit. If the child's age has to be locked in, you must have the I-140 approved. So it's absolutely necessary to have the I-140 approval too. So once you have the final action date becomes current, I will do premium processing immediately. And there are ways where you can get the premium processing very fast, because right now we are noticing that not all, but some of the cases, when we file the premium processing, they are rejecting the premium processing. They're filing it again, they're rejecting again. Now, about 90% of our cases already got accepted and most of them got approved who have filed for the premium processing. There are 10% of the cases we are filing, they're sending back, filing, sending back. Now, in your case, since you have more urgency though, I will have 2 premium processing, one going like this and one going like this every 2-3 days. I don't care if you lose $2,500 extra. If they accept first one and the second one, I don't care. I mean, if I were you, I wouldn't care. I would tend to lose, I don't care. But I want my premium processing to be accepted. So you may have to do that extra step of sending it frequently, every 2 days, premium processing, and they will be able to accept it. And they're unable to find out why they are accepting, why they're rejecting the premium processing. There is no logic at this point of time. Even though the previous labor certification was not given to the Texas Service Center, which is the only place right now to file the downgrade application, but still they're accepting some people, not accepting some people. We don't have any reason why they're accepting or rejecting. So right now, keep trying, you'll get it. But of course, since you have a teenage kid, you don't want to try it right now, which makes very good sense. As soon as the premium processing there, you go for it.
Cherub from YouTube wants to know what happens if you change roles in the current company with a green card application that was filed under the filing date chart. So with the filing date chart, we expect it to be sometime before the priority date is actually current, but you do qualify for AC-21 even with your current company. So what you have to look at is, has your 485 been pending for at least 180 days? And then you have to compare the job that you were sponsored for with the new role that you're looking to move into and make sure they qualify as same or similar occupational category. As long as that requirement is met, then your existing employer can file an I-485 Supplement J to inform USCIS of the new role and that you qualify for AC-21.
Bhushan has this question: can I interfile the medicals for the dependent even if the underlying I-140 is not approved? Yes, you can. I just want to address for all those people who have not filed the medicals, you use the word called interfiling. That's a magic word that you use. And you file, send the medicals to the same place where you have sent the 485 application, and that should go to the file and adjudicate it. The only thing, Bhushan, that I don't understand is that if your I-140 is not approved, if you send the medical, they're not going to approve your green card application. Remember the 4 rules of green card application. One of the rules is that the I-140 has to be approved. If the I-140 is not approved, even if they have the medicals, they cannot grant you the green card. So I don't see a reason to do it, but there is nothing unlawful what you will be doing by sending your medicals when the I-140 is still pending.
Anirban from Facebook wants to know, if I file the downgrade from EB2 to EB3, will both EB2 and EB3 I-140s be active? Yes, assuming that the second I-140 is filed as a new I-140, not an amended I-140. We don't want to amend the EB2 I-140. We want a second I-140 filed in EB3 using the same labor certification. If you end up with 2 I-140 approvals, one in EB2 and one in EB3, they're both valid I-140s and can be used to file the adjustment of status with whichever priority date becomes current first.
Kranti has this question: EB2 to EB3, I-140 approved in February 2021. That's good. You did a premium processing. A lot of people said premium processing are not accepted. That's an evidence that premium processing got approved. Applied for 485 in October. That's good. What happens if the company withdraws the I-140 after you move to a different employer? Good question. Kranti, I'm assuming that you would have, when you're moving after 180 days after you file the adjustment of status, your I-140 is approved, so you would be filing a 485J supplement when you move to company B in May. If you have filed the 485J supplement, what the new company is, they're taking over your adjustment of status from company A to company B. If the company A withdraws the I-140 after you moved in, after you file the 485J supplement, what will happen to your 485 application? Nothing will happen. It's going to continue as it is. No negative effect. And it is a law that it's called AC-21 portability that allows you to move from company A to company B as long as the company's job is in the similar occupation as what the previous occupation is, and the company B files something called AC-21. In 2017, they have got a form called 485J supplement. If company B files it, you will be in good shape, absolutely no problem with it.
VJ from YouTube wants to know if a person who has an I-140 approval with company A and that company is later acquired by company B, what changes have to be made to ensure the I-140 is still valid? So you have to make sure that that acquisition by company B is considered, qualifies as what we call a successor in interest, to where company B is taking over the immigration liabilities of company A, and it's a total acquisition. They're hiring all the people from company A to company B in the same job under the same terms and conditions. So assuming that company B is truly a successor in interest, they do need to file another I-140. They have to file an amended I-140 using your previous employer's labor certification. And they have to document that the new company has the ability to pay your salary, the offered wage, and then submit all of the I-140 documentation all over again so that USCIS can issue an approval notice in company B's name.
Shiva has this question, and this is a very bit sensitive, looks like easy question though. Filed 485 in October 2020 without medicals, got my medicals in November 2020. Can I submit them anytime until they are valid or during RFE or interview? Well, here's the problem, Shiva. Those medicals are no longer valid. Once the medical has been signed, you have to file the medical within 60 days after the medical has been signed. Since you got the medicals in November, it's November, so December, January, February, March, it's 4 months. It's no longer valid. So never take the things in your hand. These are very sensitive. If you would get an RFE, you would respond with this medical, guess what will happen? They will open the medicals, signed in November, send the wrong thing, deny the 485 application. That could happen. This is a very serious matter. Now, either you get the medicals done one more time and send it to them, or once the RFE comes in, get a fresh medicals, or when the interview comes in, get the fresh medicals. Don't use the November 2020 medicals. It's very dangerous for you.
Srikanth from YouTube is working for company A, planning to transfer to company B, and wants to know if you can work for both companies during the transfer period. No. You can only work for one company or the other unless it is not a transfer, but a concurrent H1b. And that would only be if you want to continue working for both companies throughout the entire approval period. But no, you can't work for two companies at the same time.
I just want to add to what I said about the medicals, though. The medical examination has to be sent to the USCIS within 2 months. Once you send it to the USCIS, though, the medical is valid 2 years from the time the doctor signs it. So the 2 years is not when you can send it to the USCIS. It's only 2 months that you can send it to the USCIS. Once you send it to it, it's valid for 2 years. Question from Amit from YouTube. Can I change my residence in the same city when my perm process is going on? Absolutely you can. No problem, will not cause any problem for you at all.
Shanaz from YouTube wants to know, I'm on F1 full-time, my H1b got picked and will be filing for it. Can I do CPT in the summer? It depends on what you mean by CPT. If you mean that you're currently an F1 student, have not graduated yet, and are still taking classes and want to do a summer internship while you're in F1 status, that is fine. If you're talking about you have run out of OPT time after you graduated and you want to use CPT day one in a new program to be able to keep working, that is not fine. I think you're talking about the first option, since you mentioned you're still in F1 status full time, so that should not be a problem at all.
Woody has this question. My I-140 is approved more than 180 days after filing the adjustment of status. Once we get the EAD, do we need to work on EAD? Can we be without job on EAD? Since you are the primary applicant, you must have a continuous job offer at all times. You cannot stay unemployed. That may be a cause for your 485 denial. There's another question somebody's asking. This person is a dependent on the 485. She's not the main applicant. She's asking the question, what is the difference between the H4 EAD and adjustment of status EAD? Practically not much different. One is called C9, one is called C26. With H4 EAD or a dependent EAD, you can work, you don't have to work. You can be a Microsoft CEO, you can flip a burger in McDonald's. Either of those things are fine. The only difference between, mostly the difference between the adjustment of status EAD is that when you file for the extension of the adjustment of status EAD, while the extension is pending, you can work for a period of 180 days. But when it comes to the case of the H4 EAD, if the EAD expires, you cannot work. Now, when I speak about the adjustment of status EAD, 180 days you can work, it's only for the adjustment of status EAD extension that you can work for 180 days. If you just file for the adjustment of status EAD, you are not allowed to work until you receive the EAD.
Funindra from Facebook wants to know, how likely are perm processing times going to be moving faster over the next few weeks? He filed in November and wants to know how long it might take for the perm to be approved. Processing times are not getting better. I have not seen any plans by the Department of Labor to make them better. They're moving very slowly. I think a lot of it was due to all of the back and forth about the prevailing wages that happened between October and January, and then having to go back and reissue prevailing wages that were already done after that regulation was blocked. But processing times are quite long. I think they're still working on applications filed last June. So it's going to be another couple of months.
For the perm, which one are we?
Perm.
So perm, they're approving in August and later.
August. We moved on to August. Sorry about that.
Rockstar, I have a DUI in 2007, filed AOS in October 2020. Fingerprints are getting done tomorrow. What are the chances of interview waiver? I would say your chance of interview waiver is zero, absolutely zero. Now, will you have any problem in getting the green card? Have I seen any people like you getting the green card denied? No, I have not seen anybody getting the denial in your stage. But once you have a DUI, you have the arrest, you have the records in there, they absolutely will interview you. Even under the old law before March of 2017, where it was not required to interview though, people who have a DUI or any of such kind of other things, they were being interviewed every time. I haven't seen anybody who had a DUI who has not been interviewed, so you will be interviewed, that's for sure I can say. But I'm not expecting any denial. If you take all the documents properly, they should be able to approve your application.
Karthik from YouTube has an H4 extension that was filed 7 months ago. Biometrics are done, but still not approved. Waiting, lost the current job, but does have an existing H1b visa and wants to know if you can apply for a change of status from H4 to H1 now. I'm assuming that your H4 has already expired. Which means that you're not technically in H4 status. You're in a period of authorized stay waiting for your H4 extension to be approved. And you can't file a change of status from a period of authorized stay to H1b The new employer could file a H1b consular processing, and then you can exit and get the H1b visa stamped at the consulate and come back and get back to H1b in that way. But it's very likely if you file it as a change of status, USCIS will issue you an RFE asking for the H4 approval notice. And if you still don't have it, they can issue the H1B approval but will deny the change of status and give you no I-94. That means you're going to have to exit, get the visa stamp, and come back.
Emily, I need attention of this personal question from Sumant Sharma. His priority date is 2018 February with company A. He got a good opportunity with company B. Would you leave the job, go join company B, because the priority dates are moving faster now, or would you stick with the company? Well, before I answer your question, Sumant, though, I have been predicting the priority dates more wrong than anybody else in the entire world. Believe me, I have evidence. I'm the worst lawyer in predicting the priority dates. My business partner is not far away from it. She hasn't been that good either. We have history. We have our recordings. We will go back and prove that we are the worst. But anyway, Emily, what would you do?
I mean, based on what we know at this moment, you have to look at the perm processing times and the prevailing wages, and is your employer going to start that process, the new employer, right away? Exactly. You want to know, basically, plan on this taking 2 years, assuming the new employer starts immediately. So in the next 2 years, is a 2018 priority date going to be current? It's possible by October 2022. I don't see it happening this October.
Which one? The priority date of 2018?
Yeah, unless we have some reform, which could happen.
I take the different stance. I think so. There is a good chance that the priority date may come current in October of 2021.
2018.
2018, yes. We are in January of 2015. We have extra 115,000, so he's only like 16, 17, and 18, 3 years. 2.5 years actually left.
But I feel like there's a lot more people in that 3-year span than were in the previous 3-year span.
We will see whether you are right in October.
We're both wrong, so don't listen to either of us.
I would not move, Emily. That's me, and that's you, Samantha, and that's advice. And sometimes, sorry guys, I mean, there's no clear answer to these things. These are judgment calls. Each lawyer differ on those things, and believe us, we've been wrong many times in predicting these things. So it's your judgment call, and that's what I feel. I will not move. Emily is saying that if she is in your position, she will move to a different job.
Ankur from YouTube wants to know, if you do a master's degree, a STEM master's degree on an H4 visa, are you still eligible for the master's quota, and how many times can you apply for the H1B in the master's quota? Yes, you are. You don't have to be an F1 status to qualify for the master's cap. So simply by having a U.S. master's degree, you can qualify in the master's cap, and you can do that forever because you're always going to be a master's degree holder. There's no restriction on how time period of when you get your master's versus when you get selected in the lottery.
A lot of people are asking the exact date of perm processing. Unfortunately, I checked it recently. It's anywhere between August 8th and August 18th is the perm processing timing right now. That's a perm processing that we're being filed. A lot of people are filed in November, December. I'm just announcing between August 8th and August 16th or 17th or so is where the perm processing time is right now.
Jiten from YouTube has an I-140 approved with employer A and EB2, and the employer B has filed the perm. He wants to know if he rejoins employer A for the exact same position, do they need to redo the perm process or the I-140 only? Potentially neither. If they never withdrew the EB2 I-140 that's approved and they're hiring you back for the same position, that I-140 remains valid. There's no reason to refile the I-140, and you don't need a new perm. You would need a new perm if the job is different enough to where it doesn't qualify under the original perm. But you would only have to refile the I-140 if the employer has withdrawn the approved I-140.
Emily, I may need some help in explaining this question from Naveen. I made a statement that 135,000 green cards are going to come to the 2021 October, starting from October of 2021. And I said that most of this 135,000 green cards will be taken by Indians, though. Why is that? There is a per country limit of 7%. Why would Indians get most of the 135,000 green cards?
Yes, so there is a 7% cap, but if the rest of the world doesn't use up all of the green cards available in that category, rather than letting them just go to waste, they allow the backlogged categories to use those green cards. So it can actually exceed 7%, but only if it's due to the rest of the world not using them. And when that happens, they always go to the country that's most backlogged because they distribute them based on earliest priority date. So with India being the most backlogged country, they would stand to benefit the most.
So out of the 135,000 green cards, how many would you expect India to take?
Well, what percentage does EB2 get?
So I'm just saying, because there is no backlog right now for the EB1, EB2, or EB3 for the other nationals, though, I'm expecting almost all of them to be taken by Indian nationals. And if by any chance, there may be maybe 15, 20,000 going to the other countries. Between 120,000 and 135,000 is my expectation to go to the Indian nationals.
Yeah, because that's a good point. If EB1 does not use up all of their allotment, those spill down to EB2, and those can then go to the oldest priority date.
So, and then based on the spilling over, though, there's a good chance that EB2 might move a little bit faster in this, right? Mm-hmm. Well, these are our expectations, guys. We can be wrong. The theories, what we are telling, are not wrong, but the mathematics, sometimes the number of applications that are behind the door, we are unable to study that. USCIS is not releasing the information, but it looks like the State Department, when they issued the video, though, they definitely have much more insights. They definitely have much more stats that we are unable to access, that they are able to access it.
Nilanjan from Facebook wants to know, if I join a new employer X and this employer has not processed my I-140 yet, can my spouse still work on the EAD that was given with the previous employer's approved I-140? Yes, in most situations that is possible. Assuming that EAD has not expired, it remains valid and can be used as long as you're in H1 status. And it's not required for the new I-140 to have be filed by the new employer as long as the old employer has not withdrawn the approved I-140 within 180 days of its approval date.
Do we need to have a 485J supplement approved to change the job on EAD only? Shishil Tiwari is asking the question. You do not need 485J approval. You just need to file the 485J. You do not need the approval once you have an EAD. Jay Kumar has this question. Is there a way to premium process Eb1C? Oh, unfortunately, not at this point of time. Eb1C category is not eligible for the premium processing. Eb1A, yes. Eb1B, yes. Eb2, yes. Eb3, yes. Eb1C, no, we cannot.
Sanvi from Facebook wants to know if H4 and H4 EAD processing times will move any faster. It's been more than 6 months and I still have not received biometrics yet. We're not expecting them to move faster by USCIS on their own, but we are hopeful that the class action lawsuit that was filed last week will push USCIS to fix this problem. So yes, the American Immigration Lawyers Association, along with our firm and Jonathan Wasden's firm, did file a class action lawsuit that's intended to include all types of people that are stuck in this H4 or L2 EAD delay. And we're basically asking USCIS to fix this problem, either eliminate the biometrics or waive the biometrics. We have a lot of arguments in there about why do we even have biometrics to begin with, that USCIS can use biometrics that were given at the State Department as well as the port of entry. Why do they need to do it again? The presidential proclamation that was used as the reason for the biometrics has already been revoked. So if we don't have the presidential proclamation anymore, why are we still requiring this? So we're hoping to see USCIS take action on these. We're asking that they take action on H4 EADs in 7 days. That's, a tall ask, but we're trying to get to the negotiating table so that we can fix this problem. So I would not expect USCIS to fix it on their own, but we're hopeful that that class action will give them some motivation to fix this problem for so many people.
Emily, Sanjeev from Facebook asked this question. Can we file the OPT online? Somebody told me because of the COVID we can. Is it true? We looked into it. We couldn't find a way to file it online.
We have, actually.
Huh?
We have figured it out.
What is it? Okay.
Yes.
Excellent.
So if you look at the USCIS online forms on their website, the I-765 does not appear. However, if you have a My USCIS account, it appears as an option, but only for the STEM extension, and you can file it online, and it seems to be approving quite fast.
Only STEM extension,
correct?
Not for the OPT. Okay, that's good to know.
Yeah, just discovered that today.
Okay, that's good. Thank you. So just a note that only for STEM extension you can do online. We still see that filing date's the same. How can you guys say it's moving? Well, it's moving, guys.
Well, the filing dates won't move till October.
Sorry. The final action dates are moving, yeah. Sorry, repeat again. Yeah, final action dates are moving very fast. The filing dates, we are not expecting to move at least until September. We are expecting them to move in October, wherein we'll get in September what the October is. That is the expectation. Until September, for the Eb3, we are definitely not expecting the filing dates to move. For Eb2, there is a slight chance they may move, but for Eb3, we are not expecting them to.
Chaitanya wants to know if the I-140 is not approved and the dates get current for the Eb3 downgrade, how will USCIS handle it? Will they start processing the 485? So assuming you mean the final action date and your I-140 is still pending at that point, USCIS does do some initial processing of the 485 so that they can have it pre-adjudicated, supposedly, so that when the I-140 is ultimately approved, everything's done and they can approve the 485. But I would expect that that I-140 not being approved is going to delay the 485, so you may want to get that upgraded to premium.
Funny Kumar has this question. If I have a patent in India and a journal article published in a trade journal, am I eligible for Eb1 Visa? Well, recently I had a consultation with a person who had her thing published in 300 journals, and she got her Eb1A rejected though. So it's not just publishing in the article in the trade journal. There are a lot of other things to be proven. You may want to get evaluated though, but if it's just one article published though, I'm not sure I would even file your application for Eb1A. It's not just whether you published in the trade journal. Is anybody used your article for their own articles or their own study? That is very important for me. You have got a patent, that's fine, that looks good, that's nice. But what is that product doing? Is it commercially viable? Is it helping? Is it environmentally helping? Is it something that is getting used so extensively? Let's say, for example, you got only one patent. That patent has to be, the one that is very most useful to the entire world. Yeah, you definitely are eligible for Eb1A. But if you got patent for the things that are not used very extensively, you just got the patent, that by itself may not be enough to get the Eb1A approved.
Harish from YouTube wants to know, he's currently working for Company A. His 485 will have been pending for 180 days at the end of April. Can he change locations to a different state within Company A? You still qualify for AC-21 even with the same employer, and so yes, you can use AC-21 to move the location of your work from one location to another location once your 485 has been pending for 180 days, assuming the jobs are the same, and the employer needs to submit an I-485 Supplement J.
Nikam has this question from from YouTube. My university has closed. Will the downgrade I-140 be impacted? If your university existed at the time when you graduated and it's an accredited university, if the university is closed afterwards, it will not impact your I-140. You know, there are a lot of things that are not permanent in this world, but at the time when you got the graduation, your university is in good standing, accredited, and was there, that's perfectly good. It should not impact your I-140 downgrade.
Ganesh from YouTube wants to know, do I need to go for biometrics every time I go for an extension? Well, it's every time you file an I-539. So I'm assuming when you say extension, you mean H4 extension or L2 extension, the type of extension that you would file on an I-539. Currently, the rule is yes, every time you file it, you have to go for fingerprinting. We are hoping to get rid of this rule through the class action lawsuit, so hopefully that will be successful, because it just makes no sense why this is only required for I-539s when they've come out and said there's very little issues with identity and criminal issues for I-539 applicants.
Harish has a question with regards to change in the location though. Harish, there are two kinds of company. One is a consulting company, which normally has a provision in the labor certification saying that you could be working at unanticipated locations. If that's the wording that is there in your labor certification, I have no problem in you changing after 180 days, you file the 485 application. But if it is a non-consulting company, which is a company which is a stable place of employment where you're going to be working at, you still can, but there are some things that you need to observe. Maybe file a 485, you may have to file a 485, you may don't have to file a 485, depending on whether the company still have this job offer at the existing location where they filed the labor certification. I would rather want you to consult a lawyer to make sure that you're fine. But if it's a consulting company that put in the labor certification that you could be working at under unanticipated location, I don't see any problem whatsoever at all in getting these things, in you changing the state.
Vic S from YouTube wants to know, any update on Schedule A physical therapist downgrading, any approvals? So I do have, my case is still pending. I have heard through other attorneys that at least one attorney has received a request for evidence on the downgrade I-140, asking why the prevailing wage determination is expired at the time of filing. Don't have the results of that RFE yet, and I don't know if it's a trend or just a random RFE, but we'll definitely update you as we have more news on that. I think we're out of time for today. Thank you for joining us. If we didn't get to your question, remember we do have a daily Zoom that you can join and speak with Rahul on video to get your questions answered. Go to rnlawgroup.com for that schedule, and you can always set up a consultation with us or any of the attorneys here in our office at rnlawgroup.com. You can schedule it online.
And I also want to mention to you guys that it's been on April 1st of 2021, we would be completing our 24th years of being in business. We started our business in April 1st of 1997. That'll be the 24th year. It's a 24th anniversary on April 1st for us. Thank you guys for your patronage and being with us for all these years. Thank you very much.